Alrighty, this is We the People News. Not attorney, not giving legal advice. Never look straight forward. Always look around you. Be able to protect yourself by any means necessary. Alright? This is a continuing part of another court date of Kirk here. Okay? Or clerk. K-U-R-T. Alright? And I explained before, and some of you guys are new here, that he is actually going through the legal process, using all the correct words and documents of the civil procedures and federal procedures and all this kind of stuff in his claims of suing Seattle and a bunch of members there. And so they decided to retaliate. And if you look on the previous deal, the views got 300 something views about the news station saying his wife got shot and this, that, here, and there. And, well, he was never married to the woman. And he's been trying to track her down to serve her papers to go to court and all this kind of stuff. And a bunch of things all going on. And he's got a mess on his hand that he's been fighting for the past couple of years. And since I'm led to believe that the city and the state and county and all of them are losing against him, go check out the video of what the news said. Okay? But the main part is they kind of go into this sovereign citizen acting as, and they're doing the exact same thing as what you guys, some of y'all call sovereign citizens, when he's actually going through the process and notices and civil rules of procedures and all that, and yet treated the exact same way. So I'm running behind schedule and all that. Been a busy man. But a couple of videos back, he had a court date with a different judge. So this was actually a next day of another court he had with a different judge he's been involved with before. And this judge knows him. And so let's just come through here and check out what she has to say, compare to what this other judge said in the previous video. Okay? On the previous video, remember, she wants to order him to have a psych valve done to him. And when they don't get their way, that's what they do. Okay? I'm just saying. But this judge is saying, I know you and, you're competent and all this kind of stuff. Let's proceed forward.
That's gladly going to pull some of your teeth if necessary.
Yeah, so I don't know which constitutional right my right to dental floss is protected under, but have people research that.
Yeah, well, that's something interesting to explore, I'm sure.
Yeah. Mm-hmm. Okay, well, hey, I'll let you go.
Okay.
Tell everybody hi.
Yes,
Okay.
Thank you, first. Okay, thanks. Bye. How do you?
Now, the last piece of business we have is his hearing yesterday in the city municipal court. And it's quite interesting. This slimy judge.
Let's pause that for you. Reminder for y'all. For him, it was a couple of days, or yesterday or the day before, or whatever. I am probably a good couple of weeks behind. Didn't check out the days and all that when I did the previous videos. So, well, this one says 12 days ago. There you go. Problem solved. Let's go.
Is also a defendant in one of Kurt's civil cases. But she didn't reveal that. I mean, obviously she and Kurt knew this, but she didn't reveal that to us until the end of the hearing when she ended up recusing herself. So we've got them a little bit pushed on their heels, but we have to keep the pressure up. We need people to be calling local newspapers and TV shows. If you know a big YouTube channel or some other, civil rights auditor, the civil rights lawyer, we're trying to reach out to him. The there's any number of people that are doing this type of work. And so if y'all know of any, please contact them, get them some information. We're trying to get a little overview script for people that we can post, and y'all be able to read it. But you know enough to know that rights are being violated. The writ of habeas corpus needs to be filed and needs to be, reviewed and ruled upon, so we can either appeal it to the Ninth Circuit, or we can get him out and get him in writing his own stuff, because it said it's enormous, all of his cases, and the best person to do that would be Kurt. So I'm going to end this with his hearing. And please, if you feel compelled to call the FBI, the DOJ, your representatives, senators, any of these things, take an initiative here. There's a lot going on that we're busy with in the background too, trying to get these things put together to get it out to you guys. But there's people writing stuff for the habeas, and we're trying to get them file it properly and rule on it. And so we need some of you guys to start calling the Western District of Washington, which is in Seattle. Press the 0. You can talk to a representative and then just be polite, give them the case number. And I will post that with the phone number. As you saw the phone number earlier with case number, and I'll try to leave it up here. But call them, ask.
By the way, if you guys get Telegram, try to reach out to the Big Sib chat. Okay, there's a lot of people doing pro se there. So if you want to learn, they're sharing for free their documents, and Fawn's actually started a lot of this as well. And you guys are going to learn a lot of stuff from that Telegram. All right, so subscribe to it. There's documents left and right that people write up, and they communicate with one another what they should do and us that here and there. And they're going by the legalese, the civil rules of procedure and federal rules of procedure, in the correct manner and the correct standing. And this tells you how corrupt when you're outside the bar union.
Why a writ of habeas corpus with a man illegally detained and being deprived of constitutional rights is being allowed to sit in jail while the Western District of Washington sits on their hands. This is inexcusable, and they know it, and so we need to let them know we know it. So I'll leave you with these with the court hearing, and it's interesting. It's certainly interesting. This is gonna be fireworks here before it's over. So can't wait to get him to a place that he can handle his own stuff. But here we go.
Okay, are we ready on the next case?
Yes, Lauren. Next matters we can call are the Kurt and Truth matters. These are cases numbers 676207, 676175, 675405, 656748, 656749, 669389, 676463, 676216, 676492, and 671384.
And just a reminder, people, he's doing this on his own. Of course, with the help with Telegram and all that kind of stuff. But this is a lot for any lawyer to take on, let alone people researching law themselves and not going to law school. Okay, so you got to give the man every credit to stand on his rights and belief. And again, he's suing them.
All of this.
Okay, counsel.
So I'm the only counsel on this case, Your Honor, and pro se Kurt Benshu. There appears to have been an error on the part of the Department of Public Defense by which Mr. Reagan, Roy, I believe his name is, was a notice of appearance was filed on his behalf in case number 675405, despite my repeated communications by phone, by text, and by email to senior management at the DPD to demand that they stop assigning attorneys to my case to violate my rights. So I'm not pointing any fingers or blaming Mr. Roy, but the notice of appearance filed on his behalf was inappropriate and illegal.
Well, no, not illegal. Because everybody has a right to counsel, and so because of that, attorneys are assigned to individuals who qualify as.
Now, they may not agree with me, but on my outlook and my research, okay, counsel is to sit there with you and help you along, but you are to speak still for your behalf. Now, what the attorneys do, come in and they just confiscate all your rights. Once you get attorney, you waive all your rights. Read the paperwork, y'all. The counsels, true counsels before bar members interrupted us, was there to help you. And that was all their job was, is just to help you move along in the courts. They weren't even allowed to speak to the judge or to the prosecutor. They was only to speak to yourself and tell you what you should, help you along in your speaking and all that kind of stuff.
Needing assistance if they can't afford an attorney on their own, or they want to proceed pro se. Mr. Bishop, you have quite a few cases.
I have objection. I have quite a few malicious prosecutions.
Okay, so no, I'm not going to characterize them as that, but if you'd like to, but I'm just saying is you're facing quite a few charges, and Mr. Roy, RFDPD, might not be aware that on the majority of your cases that you have been representing yourself. So with that being said, is I will allow Mr. Roy to withdraw, to put in a notice of withdrawal, and we will continue to handle your cases because, as I said, majority of the time you have represented yourself. Okay, so Mr. Roy?
Just to be clear, Your Honor, does that mean Mr. Benshew's request to go pro se on that case is granted?
It is granted, yes.
Thank you, Your Honor.
And Mr. Benshew has gone through the colloquy. He has been very expressive. He has represented himself in front of me several times on his other cases. So I know he is aware of the colloquy on when not wanting a counsel to represent, and that he feels confident that he can represent himself. Am I correct, Mr. Benshew?
I believe so, and so am I correct in my understanding that the court acknowledges that I am competent to proceed based upon past litigation?
Yes, because you've gone through the colloquy before, understanding where the judge asked you, do you understand about this case? Do you understand you'll be representing yourself? You're expected to act as your own attorney. You will not be given assistance. Do you recall that, or do you need me to go over?
I fully recall that, Your Honor, and I would note for the record that there is a serious contradiction between this court and King County Superior Court, because just yesterday I was prevented from proceeding pro se when the judge claimed that that she had concerns that I was mentally incompetent, and she delayed the case another 14 days until the 31st. And allegedly is ordering a mental health evaluation. So there is, there's
her perception of my. No, we don't have to. We're in a different court. We're both independently elected judges. I'm very familiar with you. I don't know what her familiarity is with you. What one judge decides does not impact what I decide, depending on what stage we're at. But particularly, that's Superior Court, this is Municipal Court. So, with that being said, as long I have not gotten any indication that you are not understanding, the law allows her, if she believes that you may not be able to represent yourself, to do what we call a 1077 and have a competency hearing where you would then be interviewed by a mental health evaluator. So that's her process. So now, since you are finally here and you have these cases, how would you be proceeding on them?
Well, first I'd like to address the two initiating cases, 656-748 and 656-749, both of which are a flagrant violation of the Civil Rights Act of 1964.
Okay,
Go through
I'm not
cases
trying
such
to
as
be
Kansas
rude
City,
here.
Rockville.
Okay, you know, Mr. Benshaw, this is not the hearing for this.
Actually,
We are, no.
Jurisdiction is a threshold matter, Your Honor. You know that, I know that.
Stop, Mr. Benshaw, I'm not going through this with you. I'm trying to tell you this is not the hearing, not that you can't make that argument. This is a.
It is. Jurisdiction is a threshold matter.
Okay, Mr. Benshaw. Mr. Benshaw, stop. No, it's not a stop. I am the judge. I'm trying to tell you, we are not going to argue about jurisdiction today. It's pre-trial hearings.
I'm not arguing.
I'm trying to tell you is.
I came down here to remind you that you don't have jurisdiction.
Mr. Benshaw, Mr. Benshaw, if you have arguments, this is not the hearing to raise constitutional
You do not
arguments.
have jurisdiction to speak. I will let you speak when I'm
Okay,
done
well,
Stop right there. Listen to what she just said. This is not really the courtroom to argue constitutional. Well, did she or did she not sign an oath of office, people? Okay? So I am led to believe this is administrative, okay? Due to the 1947 Act. And by the way, it was in 1947 when Congress put that in action by the attorneys, of all people. All right, the attorneys pushed that through. Now, if this was not the case, why do we not have administrative with our founding fathers? Because England had administrative then. Why did that not be in with the Constitution for the people?
no, that's not how this works. I do have jurisdiction. Mr. Benshaw,
And again, she cannot really explain how she has it. So far, there has not been a claimant that arises from this. Where's the claimant?
concluded this hearing. We've concluded this hearing. Mr. Benshaw, we are concluding. We are concluding this. We are concluding this hearing because you've decided you are the judge and that you are moving. I've tried to tell you this is a pre-trial hearing. No motions for dismissal or lack of jurisdictions happen at pre-trial hearing calendars. So hold on. Hold on. If you would let me talk, I'm going to try to tell you very politely. Pre-trial hearings are either to set this matter for trial or to continue it while you still do investigations and negotiations with the prosecutor's office. If you set this matter for trial, then we will set motions hearings. At those motions hearings, you can make the argument of lack of jurisdiction by the court, lack of constitutional, and lack of constitution in whatever area you think that we're violating the Constitution and other matters. This is not the hearing in which the court will consider lengthy, long, ongoing motions hearings. This is not the time. So the question I have for you before you begin is, are you either setting these cases for trial so you can therefore then make those arguments, or are you continuing because you need more police reports, discovery, or to negotiate with the city on these cases?
I offered.
We're going to pause right there for a second again. Now, we talked about saying guilty, no contest, and not guilty, right? This is what they're trying to do. They want him my belief, okay, I'm not an attorney, not giving legal advice, they say educational purposes only, in my opinion. They want him to make a claim so the burden of proof is off the state. He's not falling for it. And he does have every right in this courtroom, right here, right now, to challenge jurisdiction, because they have to have subject matter jurisdiction minimum to even proceed in a court of any courts, all the way from the lowest to the lowest to the highest to the highest. He has a right to challenge jurisdiction, and they all, case after case after case, must tell him how they have it. And again, everybody keeps saying a sovereign citizen thing, but this guy is going through the legal process correctly, and they're doing the exact same thing.
Negotiate with the city. I offered that if they would stop the malicious prosecutions and the RICO enterprise and stop violating my rights, that I'd be happy to do a global resolution. I offered that repeatedly to Dallas Lake Pierre, who was representing the city in case number 2:24-CB.
That is a civil matter.
I understand. But in that civil matter, there were criminal law violations alleged and evidenced perpetrated by Katrina Allen, Sakila Serafan, and others. I won't mention anybody that's in this courtroom. So there is no need to set this for trial because the court doesn't have jurisdiction. I don't have any more need to do investigative work. I have all the facts of what's been going on. The court does not have jurisdiction. The prosecutor is engaging in a malicious prosecution, and it's noteworthy that neither Ms. Katrina Allen nor Ms. Sakila Serafan are here. They're both defendants. I caught them red-handed in perpetrating this RICO enterprise. The court does not have jurisdiction for the quote-unquote trespass cases, and Supreme Court case law, there's no question. In fact, it's laughable this court has proceeded in maliciously prosecuting me in those cases for nearly 4 years. As far as the DV cases, which are all the other ones, this court never had jurisdiction because under RCW 7.105.050 subsection 1, parts A and D, only King County Superior Court could exercise jurisdiction in the alleged violation of the allegedly valid restraining order that was issued by Judge Keenan. This court also violated the priority of action doctrine. When another court asserts jurisdiction, they have jurisdiction. That's also what happened when King County alleged that they had jurisdiction in the family court proceeding. I have shown in court over and over and over again that the mother of my son, along with her prostitute perjurer girlfriend, they committed perjury, foundational to erroneously initiating case number 21-5-00680-6, along with
Now, recall this, girlfriend, prostitution, okay? What the news said, and if you go back and use the video of the news of the SWAT team hitting his house, all right, they said it was his wife and that she was shot in the legs. But she's trying to, and if there was a restraining order, allegedly, against her, or for him against her, what was she doing at his house?
Not trying to cut you off, but I am not going to base a ruling. Since I am a defendant in your action, I'm going to recuse myself from hearing anything further because you're bringing in that civil matter which you have named me as a defendant. We're going to try to find a judge who has either has not been identified as a defendant in your civil case or has not had your case yet because the circumstances of which your cases have moved through this courthouse. So at this time, I'm going to stop, exclude speedy trial. We're going to get you a date, and then I'm going to try to find an attorney who will not have any bias or anything else in regards. Okay.
I did just want to note that this was going to be a city trial set, but given
He's not. It doesn't matter what the city is going to do here at this point. He does not want to set this matter for trial. He believes at this point, that the court should make a ruling on his arguments. The court is not making any rulings. The court is recusing itself because I am a named defendant in the civil lawsuit. So basically, all I'm doing is punting it to the next judge that we can find.
And, Miss, I don't know your name, Miss Prosecutor?
Yeah.
Yeah, are you aware, sorry, I didn't know your name, are